Good morning. Let's go ahead and get started. Thank you so much for joining us for today's Wednesday webinar. Today, we are going to discuss Social Security disability, more specifically as it relates to PTSD claims. Before we get started, I want to give our typical disclaimer that today's webinar is not intended to be legal advice, but is instead intended to give additional background and information for those who are considering applying or have applied for Social Security disability benefits and have PTSD as one of their main reasons behind submitting that application. I also want to make mention that we don't answer live questions on the webinar, and we are limited in what we can respond to in comments on the replay. And the reason for that is not because we don't want to help and we don't want to answer your questions, but is actually because we typically need quite a bit more information than just the baseline basics to actually give a good answer. And so we do try to set time aside to answer those questions. We'll drop a link in the chat now on the live for those who are on the live and want to schedule a call. We are happy to answer any questions. And if you are watching on the replay, that link to schedule a call to ask questions that you might have will be down below. If for some reason we cannot help you, we do try to point you in the right direction of someone who can. So with our warnings kind of out of the way, let's go ahead and get started. Here's our roadmap for today. We'll start out talking about Social Security disability basics, then we'll move into some of the guidance. We'll talk about the listing for PTSD. We'll talk about some considerations. And then finally, we close out the webinar by talking about some of the things an attorney may be able to help you do with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I am the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, and we help clients with their Social Security disability claims, both SSDI and SSI, at the agency levels, which means we focus our practice on the initial application through the administrative law judge hearing and sometimes even the appeals council. We do not handle federal appeals at this time. Okay, here is background on the two different programs, what I like to call Social Security disability basics. One of the first things that I always try to educate people when they call in for the first time and I'm talking to them is that there are two different Social Security disability programs. Not only do people get them confused, SSI mixed up with SSDI, but they also don't always know that there are two. They certainly don't know what the requirements are. And a good portion of that is because you don't do this every day the way we do. There are two Social Security disability programs. They're both going to require that you be disabled and unable to work for a period of at least 12 months due to one or more physical and or mental impairment. The physical or mental impairment does have to be severe, which means it does have to, of course, have an impact on your day-to-day functioning and activities. Okay, so they both have that requirement that you do have to be disabled. SSI, if you're above 65, you don't have to be disabled, but we don't handle the above 65 claims for SSI. That's a different focus. We handle Social Security disability claims with SSDI and SSI, so therefore they're both going to require that finding of disability. Where they differ is SSDI has a work history requirement. You have to have sufficient number of work credits, meaning you have to have worked and paid into the Social Security system long enough to be able to qualify. Typically, we say that that means that you have to have worked for 5 of the last 10 years, though that can change sometimes depending on your age, okay? Every year, Social Security picks a dollar amount to be the amount of money that you have to earn one work credit for that quarter, basically. You have to earn 4 credits in the year, so 1 credit per quarter, and that's the max. You can only earn 4 credits a year. And if you have those 4 credits, you're insured for that year. So you have to have that insurance for 5 of the last 10 years is typically what we say. SSI does not have a work history requirement, but instead you have to have limited income and resources. Income is, it's not really a gray area, but it just varies a lot more because it depends on the household size and other factors. Assets is pretty black and white. You cannot have more than $2,000 in assets if you are single and more than $3,000 in assets if you are married and still qualify for SSI benefits. What this means is that with SSDI having the work history requirement and SSI having the income and asset restriction, that there is a portion of the population that falls into kind of a donut hole and won't qualify for either one. Unfortunately, I see a lot of stay-at-home parents falling into this hole because they haven't worked 5 of the last 10 years because they've been outside of the home. They've worked inside the home, but they have not worked and paid into Social Security for 5 of the last 10 years. And then same with SSI, they've been able to stay home as a parent because they typically have a partner who is able to work and provide. And so that will usually put them over the income and or asset thresholds. Otherwise, like I said, as long as you've got the sufficient work credits, SSDI can be an option. As long as you have below the income and asset threshold requirements, SSI might be an option. Okay. So those are the two programs and the similarities and the differences between them. Here's the 5-step evaluation process that Social Security is going to follow when you submit your application. And before they even get to this, they're going to make sure that you meet that other prong, not the disability prong, but with SSDI, they're going to first make sure you have enough credits. And with SSI, they're going to first make sure your income and resources are below their limits. If you don't have enough credits and you've applied for SSDI, or your income or assets are above the threshold and you've applied for SSI, you'll usually get a pretty rapid denial because they won't even get to this 5-step evaluation process. They'll just look at it and they'll say, unfortunately, you don't have enough work credits for SSDI. Or with SSI, they'll say your income or your assets, whichever it is, exceeds our thresholds and therefore you don't qualify. So if you don't meet that secondary prong, they don't get to the medical portion of evaluating the disability, which is what this 5-step evaluation process is. So what they're going to look at is they're going to look to see, are you engaging in substantial gainful activity? And for 2023, substantial gainful activity is defined as working more than 20 hours a week or earning more than $1,470 a month in gross earnings. Okay, so that's gross earnings, not net after taxes and insurance and everything else gets taken out. If you are engaging in substantial gainful activity, so if you are working more than 20 hours a week, or you are earning more than $1,470 a month, then Social Security is going to deny it at step 1, and they're going to say you're engaging in substantial gainful activity. Therefore, by our definition, you cannot be found disabled. If you are not engaging in substantial gainful activity, then it'll move to step 2, where they really start to look at the medical records to see, is there one or more severe medically determinable impairments? What they're looking for, we'll talk about in a minute as far as kind of what specific findings. But as long as the medical records indicate that you do have at least one severe medically determinable impairment, then they will move to step 3. If you don't have at least one severe impairment according to the medical records, then they will usually stop there and deny the claim and say, again, you can't be disabled by our definition. And this time it's because you don't have at least one severe impairment that's impacting your ability to function on a daily basis. If you, like I said, if you do have at least one severe impairment, they'll move to step 3, where they'll look at the listings. And we'll talk about the PTSD listing in just a minute. They'll look at the medical records to see, do you meet or equal a listing? If you're applied for PTSD as one of your impairments, they will look at listing 1215. If you do meet or equal a listing, the analysis stops there and you'll get an approval letter. If you don't meet or equal the listing, it goes to step 4, where the agency again looks at the medical records and they create a residual functional capacity for you based on the records, which is what they believe you are capable of performing on a daily basis as far as physical and mental activities. Using that RFC, they will compare it to your past work, and they will look at your past work in the Dictionary of Occupational Titles to see, can an individual with this RFC go back and perform this past relevant work? If you cannot, then they will move to step 5. If you can engage in your past relevant work based on their RFC, you'll usually get a denial at step 4. If you cannot engage in your past work with that RFC, they'll go to step 5 and they'll look to see, can you engage in any other work? Are there any other jobs in the national economy that an individual with your age, education, and work history can perform with your RFC? Okay, so that's the 5-step evaluation process. If you can engage in other work, you'll get a denial. If you cannot engage in your past work or any other work, then you can usually get an approval at step 5. All right, here are some considerations for PTSD claims. Social Security considers their stressor and trauma-related disorders, which is the listing that we're looking at, to be characterized by experiencing or witnessing a traumatic or stressful event, or learning of a traumatic event that occurred to a close family member or close friend, and the psychological aftermath of clinically significant effects on functioning. You'll see the next paragraph goes through what some of the signs and symptoms may include, such as distressing memories, dreams, or flashbacks that are related to that stressor. Avoidant behavior often is a component, diminished interest or participation in significant activities, persistent negative emotional states, or a persistent inability to experience positive emotions, anxiety, irritability, aggression, exaggerated startle response, difficulty concentrating, and sleep disturbances. Depression, bipolar, related disorders, anxiety disorders, neurocognitive disorders are all evaluated under different listings with different qualifications. So if those are also a component, those other listings will be looked at, but specific to PTSD, which again, Social Security puts under the umbrella of trauma and stressor related disorders, that's what we're going to look at here. I told you earlier that we will look at what Social Security is looking at in their medical records. And here's kind of that list. They do need records from a physician, psychologist. It can include PA, a psych nurse practitioner, a licensed clinical social worker, or a clinical mental health counselor. And then as you'll see, it goes through quite more than a handful really of what they are looking for in the medical records, including not only your reported symptoms, but also your medical, psychiatric, and psychological history. They're also going to look for any type of medications that you take. What kind, the dosage, does it help? Does it hurt? Does it have negative side effects? They're going to look at any therapies that you receive. How often? What's the frequency? What type of therapy are you receiving? How long are the therapy sessions? And are you seeing a beneficial effect from those therapy sessions? If so, what is that beneficial effect? As I mentioned, they're going to look at side effects. They're going to also look at observations and descriptions of how you function when you go visit the doctor. And oftentimes that's something that we can't help. And that's part of why that's what they look at. They'll also, of course, look for any information about any abnormalities, including any sensory, motor, or speech abnormalities, the expected duration of your symptoms and signs, as well as their effects on your functioning, both currently as well as in the future. Okay, there were a couple that I left out, lab findings, imaging results, psychological testing. They do review and consider all of those as well. Mental status exams, clinical interviews, rating scales, all kinds of different things that they will look at in the medical records to make their ultimate finding of disability or not. All right, here's the listing. 1215, there's two ways you can meet it, by either meeting A and B or A and C. So you'll see A will be on the slide for both. The difference will be at the bottom of the slide for each. So A is going to require medical documentation of all of those 5 things. It's going to require medical documentation of exposure to actual or threatened death, serious injury, or violence. It's going to require medical documentation of a subsequent involuntary re-experiencing of that traumatic event, such as intrusive memories, dreams, flashbacks. Going to require an avoidance of external reminders of the event. Going to require medical documentation of a disturbance in your mood or behavior, as well as increases in your arousal and reactivity. For example, if you've got an exaggerated startle response, or you've got difficulty sleeping because of the PTSD, that's what they're going to be looking for in the medical documentation for Part A. So that you've got to have to meet the listing either way. The kind of the second prong for one way to meet is by having an extreme limitation of one of these four or a marked limitation of two of the following areas of mental functioning. So your ability to understand, remember, or apply information, your ability to interact with others, your ability to concentrate, persist, or maintain pace, or your ability to adapt or manage oneself. So those are the four areas of mental functioning. So again, to meet 1215 A and B, you've got to meet A, you've got to have medical documentation of all five of those, as well as an extreme limitation of one or marked limitation of two of the four areas of mental functioning. To meet A and C, you've again got to meet all five and have medical documentation of all five of those listed in A, as well as have your medical disorder be considered serious and persistent, meaning you have a medically documented history of the existence of the PTSD or other trauma or stressor-related disorder over a period of at least 2 years. And there's evidence of medical treatment, mental health therapy, psychosocial support, or a highly structured setting that is ongoing and that minimizes and diminishes the symptoms and signs of your mental disorder. And you have a marginal adjustment, meaning you are minimally able to adapt to changes that happen in your environment or to demands that are not already a part of your daily life. Okay, so those are the two ways to meet the PTSD listing. Medical records are critical. And remember, as we talked about before, the issue in Social Security disability cases is not just can you go back to your past work, but can you perform any job that exists in the national economy? I oftentimes have people call in and they say, well, there's no way I can go back and do what I used to do. And that might be true, but if you're, 38 years old, Social Security is going to say, well, you can go do this other thing that requires maybe less mental effort. If you are 50 or older, the grid rules might apply. And that's particularly relevant if you have physical impairments in addition to your PTSD. So typically, because the grid rules do focus more on the physical aspect, they put you into different categories of RFC. So 50 or older, the grid rules might apply. But again, that's particularly more relevant if you have physical impairments. Functional capacity can also be relevant. Again, particularly if you have physical impairments in addition to the PTSD. Objective medical records are important, and they can be really hard to get in mental health cases. Therefore, it's really important to have a treating provider who understands what you're going through and who can properly document the file, connecting it back to your PTSD. I was just talking with a potential client or client this morning about their mental health records and how, the provider wasn't always notating everything that they had talked about. And I said, I understand your concern and I share your concern. And unfortunately, that happens frequently, especially with mental health things. And it's because the provider is focused on treating you. They're not focused on papering the file for a future disability claim. And so I always encourage people, as soon as you know you're going to apply for disability, let your providers know. This goes for both mental health and physical health. Let your providers know, because they may very well be willing and able to notate in the file differences than they were previously, because previously they were documenting the file just for the treatment. And now, some providers are willing to continue to document the file for treatment, of course, but they're also willing to put in additional statements that would be helpful to disability. And so that's always my recommendation, is to, as soon as you know you're applying, certainly let your providers know. And that way it can be really helpful to have them on your side from that medical perspective. All right. Here's a list of how an attorney can help you. As I mentioned at the beginning, this is not an exhaustive list, but it kind of covers some of the things that we do handle most often. So we do provide court guidance on what correspondence from Social Security actually means. We can review any documents that you've got for accuracy and completeness and discuss what Social Security is looking for in those requested forms in some of the correspondence that they sent. We also can file necessary appeals, either if you are already a client of ours and we get a denial, or you call us shortly after a denial and we're able to get the intake process done before the appeal is due. We review your medical records and case file, and sometimes, as I just kind of alluded to, we can discuss what additional records might be helpful in your case. We work with you to provide relevant updates to and from Social Security throughout your claim. If you have to go to a hearing, we do prepare you for that hearing. And then, of course, we question you and any witnesses during that hearing. And I always like to say, too, witnesses, it's not typically, what you might think of as, well, my daughter would like to testify, or my husband, or, my next door neighbor who always comes over and helps out. We have a different kind of way that we use to get that witness testimony in. Not all hearings have time for additional third-party witnesses. That's usually you and the vocational witness. Sometimes there's also a medical witness present. The vocational and the medical witness are both hired by Social Security to be there to testify. They don't testify necessarily on Social Security's behalf. They are supposed to be an impartial witness, but that is what I mean by we question you and any witnesses during the hearing. Okay. Here's our contact information. If you have any questions, please do feel free to reach out, give us a call, send us an email. We'll drop a link in the chat again if you have additional questions and would like to schedule a call. And again, on the replay, that link to schedule a call is down below. Thank you so much for joining us today. Have a wonderful day.